Journey. I have promised that we'll come back with a part 2 of a law of a contract, and here we are heading to the part 2 with answering all the core questions. We are going to advance Gloria now on a well theory and its In Error Doctrine to find out whether she has a legal binding contract with Jack based on the cluster home described in this document, and we must not apply CPA. Here we have a question number 1. Have you ever heard about what we call Cavet Subscript? Or the Cavet Subscript is a Latin term which translated to let the signer beware. This was firstly discussed in the case of Berger versus Central South African Railways Berger, and then I've given this case in full. The Supreme Court of Transvaal held that it is a sound principle of law that a man, when he signs a contract, is taken to be bound by the ordinary meaning and effect of the words which appear over his signature. So this is called the Cavet Subscript, which is Latin term. After applying the Cavet Subscript, we go straight to the actual subjective agreement, which is consensus. It reads as follows: a contract is created when the parties agree on its terms after the necessary conditions for its validity has been satisfied. Depending on the nature of the negotiations, the process of coming to an agreement may be quick or lengthy. The parties must declare their intentions to one another. These statements are often examined in the light of the offer and acceptance rules. By outlining their intentions, the first party offers the second party an offer, which the second party may accept or reject. This quick offer and acceptance analysis aids in evaluating whether and when the contract was concluded. Consensus, not offer and acceptance, sets the foundation for contract. In general, the parties may communicate their intentions in any manner, whether in writing, oral, or through behavior. For example, by a nod of the head or by raising a hand at an auction. Depending on the type of offer, whether postal or oral, there are different theories or remedies to deal with each after depending on certain requirements being met. When we are done with actually subjective agreement, we come to the first one which we have to discuss, and that one is a will theory. And they said that the basis of a contract is the will of the parties, meeting of the minds of the parties. If one party is error as regards one of the vital elements of the agreement, there is no real agreement. The result is that neither party is bound and each party may reclaim whatever it has performed. In the light of the unsatisfactory outcome of this approach, there were suggestions that this theory may be supplemented. As will be shown later, the shortcomings of the will theory in the event of dissensus are corrected by the Reliance Theory. It means that now we have to look for the Reliance Theory in order to understand more about the will theory, because the event of dissensus are corrected by the Reliance Theory. So let's see what the Reliance Theory is all about. Now let's discuss the Reliance Theory. According to this theory, as it is applied in the context of dissensus, a contract is based on the intention of one party to an agreement and the reasonable impression or reliance on his party that the other party had the same intention. It is regarded as only supplementary to the will theory. If the two parties do have coinciding intentions, there is consensus and no need to inquire whether one of the parties had any particular impression of the other's intention. If there is a material mistake by one party or both, and therefore no actual consensus, the Reliance theory acknowledges that there is a contract if one of the parties in a reasonable manner, relied on the impression that there was consensus. The Reliance theory has been applied in a number of decisions. Okay, let's see the requirements for proving a contract on the Reliance theory. Is that one of the parties to the agreement must have created in the mind of the other party the belief or reliance that they had reached a consensus. And then I gave you the Hugusan Broad feature South African Railway. The party who wants his reliance upheld must show that the reliance was reasonable in the circumstances. It is not clear whether fault is a requirement for the operation of the Reliance theory. So I was putting the Reliance, I put the Reliance theory because it supplements the will theory, right? As we have stated it even on the. Then the second one we are going to talk about is In Error Doctrine. According to Justice Error approach, a party to an agreement who raises mistake and wishes to escape contractual liability must prove not only that the mistake is material, but also that it is reasonable. So, according to the Error Doctrine, the mistake must be material and the mistake must also be reasonable. The mistakes must be material and the mistakes must be reasonable. So it means that Gloria must be able to prove that the mistake is material and able to prove that the mistake is reasonable and that material is reasonable. Okay? When we go forward, we must ensure that the In Error Doctrine is a corrective measure when dealing with the dissenters of a contract. Simply put, a party will not be held or will not be bound to an agreement if that party mistakenly gave their consent. However, the mistake must be material and reasonable, the one that I was telling you. One also needs to ascertain if the signatory understood all the contractual terms and whether the signatory was only required to understand the contract reasonably. If, for instance, the signatory was a businessman and was signing a company contract, he should know all the technical words relating to the business contract. In a standard term agreement, it will be challenging to prove mistake, but if it is intricate, it may more easily be raised. It should also be noted that if a mistake is material, then the contract is void for mistake unless a reasonable reliance is present. If a mistake is non-material, then it may be voidable. That's when we're talking about the In Error Doctrine. I put it in a simple way so that when you are writing, you're able to understand what we are talking about. Fagan CJ, in George Vias' Fermed case, he said, when can an error be said to be justice for the purpose of entitling a man to repudiate his apparent assent to a contractual term? So he's talking about the error when it is said to be justice. As I read the decisions, our courts in applying the test have taken into account the fact that there is another party involved and they have considered his position. They have in fact said, as the first party, the one who is trying to reside, being to blame in the sense that by his conduct, he has led the other party as a reasonable man to believe that he was binding himself. If his mistake is due to a misinterpretation, whether innocent or fraudulently, by the other party, then of course it is the second party who is to blame, and the first party is not bound. So this statement by Sagen means that when they check the error, they don't just say that, oh, because it's Jack who written the contract, the error is from the Jack side. No, they check whether the error is from the both sides, or whether the error is from the Jack, or whether the error is from Gloria, for the purpose of this document. And I told you about the case of Alien vs. 16 Sterling Investment, where the plaintiff's error as to the property he was purchasing was caused by the misrepresentation of the defendant agent. The agent misled the plaintiff by pointing out to him a different property to that stipulated in the deed of sale that the plaintiff signed. The court found that the plaintiff's mistake had been reasonable because it was caused by the misinterpretation of the defendant agent in pointing out the wrong property. When we apply that case to that scenario, we can see that the defendant who is Jack, the defendant agent, Sandy, has pointed out the wrong cluster, which is not the one on the document. So the mistake here is reasonable, is material and reasonable, because they were not, the mindset of the contractors were not in the same intention. So Gloria thought that she was contracting for another cluster home, whereas the document is stating somehow. So the material here on this scenario is the mistake here is material and reasonable based on misinterpretation, based on the case of investment 16 investment. So when we apply this case of 16 sterling investment, we can say that Gloria has been misrepresented by the defendant agent, who is Sandy, who's working for Jack. So plaintiff, who is a Gloria, has a case, and she can win in court based on the case of Alien vs. 16 sterling investment. And for more about the in-source error, in order to understand, you must read this document where it summarizes the case of Absa Bank Ltd vs. Trebiota Whiskey. This is the best case for you to understand more about in-source error. This one they were talking about in-source and suretyship, but you must only deal with the in-source error because we are not dealing with suretyship. So it's a very good case. It's a very good journal for you to understand about in-source error. When you read this journal, you will find a paragraph here where they said, in delivering judgment, Revelers J held that for second defendant to be successful in her plea of in-source error, she had to show that she had been misled as to the nature or terms of the suretyship. So if we can apply here to the Gloria, it means that the Gloria must show that she has been misled as to the nature of the contract, and that there's been a duty on the Jack to inform the Gloria of the consequences of signing the documents, which the Jack had failed to discharge. This was the case of the Absa, that one that we're talking about, this journal, and we are putting it in a way that it could be interpreted in the case of Jack and Gloria. And that's why we are heading straight to the duty to speak. attributes and capacity of the contract denier, the duty to speak. So Jack has a duty to speak about the consequences of the contract. And the journal goes further ahead by saying, in other words, and without attempting to formulate a hard and fast rule, in the first instance sketched above, there may be factors that point to a duty to inform, whereas in the latter instance, there may be factors suggesting the contrary. And then they've given the references. And then they said the rationale behind this is simply that since the east-west approach is usually regarded as an indirect application of the Reliance Theory, and they give the references, the question really seems to be whether the contract assertor is entitled to assume reasonably that the signature has assented to the terms in question. And then they've provided the references. And the personal attributes of the signatory and the capacity in which he or she acts may play a role in determining whether there was a reasonable belief in consensus on the part of the contract assertor in the circumstances. Nonetheless, it should be noted in this regard that there is a tendency to dwell on factors that reinforce the case for applying the Cavet Subscript rule rather than those that could suggest the contrary. We are talking about the duty to speak, which this journal has made it clear by the case of APSA, which we have shown you earlier about the APSA, that the person who has written the contract has a duty to speak, to inform the person that is signing that these are the consequences of the contract. When you sign, you are signing this contract, so that the person could understand the nature of the contract. It means that you must be well informed about the nature of the contract before you sign. You must understand the terms and conditions of the contract. So if you didn't understand, it means that you signed something which is you are not in the same intention. And this journal is a very good journal, which if you want it, we can send it to you. Then you will read it in order to understand. And again, the journal is once again in Stuart's era and suretyship. And there they are relying on the case of APSA Bank Ltd. Without Trebbiato Whiskey, the case that we told about you earlier. It's a nice journal that you must read in order to understand. So obviously you will give yourself a different conclusion, but you must know that yes, you can rely on the In Error Doctrine based on the case of Stalin investment, which we have presented the case. So thanks for watching, guys, and I hope you are going to nail this assignment because I've provided you with more information. Thank you very much. We'll meet on assignment number 2.